Hey, I'm Dr. Craig. I'm the creator of BarkingDogs.net, and I'm here today representing the Barking Dogs Coalition. The production you are watching now is the second in a sequence series of videos we've made about the barking laws. In our last video, that's a link to it that's up on your screen now. In that last video, we introduced you to the multiple household barking law, which is the most common barking law in the books, and sad to say that fraudulently unenforceable, shameful excuse for a law is probably in effect where you live. Now, in this particular video, the one you're watching now, we're going to read through the multiple household law. However, if you'd like to jump over to any of our other videos about the barking laws, just go to the description section below. There you will find annotated links to all of our barking law videos. Okay, so here we go. Like I told you in the last video, the multiple household law is all but completely, totally unenforceable. I'll bet I've talked to more barking dog noise victims than anyone else on the planet, and I have yet to meet anyone who was able to quiet their neighbor's dog by turning to that made-to-fail law. In the description section below, you can find a link to a copy of the multiple household law, so you can read along if you'd like. Or if you want, just keep watching and I'll tell you what the damn thing says. Okay, so let's get to reading that pathetic excuse for an ordinance. The first sentence reads, "Whenever the director or any animal regulation officer has reasonable cause to believe that a public nuisance, as defined in this section, exists, the director may conduct an investigation of the alleged nuisance." Now, do you see that? We're just one sentence into this foul, misleading ordinance, and we're already going to have to stop and talk about this thing. Because even though we're just one sentence in, we're already knee-deep in bullshit and sliding rapidly downhill toward a steaming, swirling cesspool of rancid deception. Because, see, in that first sentence, the devious clowns who wrote this unenforceable law have left the reader with the impression that the powers that be are going to launch an investigation whenever they have, quote, a reasonable cause to believe that somebody is force-feeding the noise of their barking dog into someone else's home. But what they don't tell you is that the animal control's way of thinking, when you go to them and report that your neighbor's dog is barking, they do not consider that to be a reasonable cause for launching an investigation into whether or not your neighbor's dog might be barking. No, they're going to need you to provide court officials with formal letters of complaint, written by one or in most cases two of your other neighbors, who have to be from different households, and all of whom have to agree to square off with the dog owner and testify against him in a formal court proceeding. And they expect you to make that happen. I gather that there's no fucking way on earth that they could possibly quiet your neighbor's dog without you first providing them with all of that. Even if you show them video of your neighbor's dog barking, to their way of thinking, that also does not comprise reasonable justification for starting an investigation. For that matter, even if an animal control officer is standing there in person, watching the dog bark, so he knows that it is definitely happening, animal control still will not accept the eyewitness account of their own animal control officer as being a reasonable reason to launch an investigation to determine if the event the animal control officer just witnessed might in fact be occurring. They don't consider that as being enough reason to even launch an investigation, much less as being proof positive of the existence of what any fool can see is clearly happening. So you see, their definition of reasonable just does not seem reasonable to me. The next sentence in the multiple household law lays out what I was telling you about. It says, whenever it is affirmed in writing by two or more persons residing in separate residences are regularly employed in the neighborhood that a public nuisance as defined in this section exists, the director shall investigate the alleged nuisance. But here's the thing. You're not going to be able to get anybody to sign on as these multiple household statutes require. Because despite this deceptive statement that would lead you to believe that all you have to do is get your neighbors to write a letter, in truth, along with the letter, you're going to have to get your neighbors to agree to take a day off from work to go into court to testify against the dog owner while he sits there and glares at them. And it will mean a state of war between the families for many years in the future. Believe me, it will. I've seen it many times, and that's exactly what's going to happen. And the people you were trying to sign up know that if they speak up, then that's how it's going to go. And when you factor in the fact that people who refuse to control their dogs are prone to belligerence, you realize that you're never going to be able to get any of your neighbors to sign on for a thing like that. I've never been able to do it, nor have I ever known anyone else who was able to do it. And in Santa Rosa, and almost certainly where you live as well, they require complaints from 3 households. Good luck with that. And as for the second part, where they say the director shall investigate, that's a total lie. He's not going to investigate a damn thing. If he was investigating, he'd be out listening for barking dogs, video recorder in hand, gathering information and interviewing witnesses. But he's not going to do that. He's just going to sit there in his office, the way they always do, waiting for you to become so upset and discouraged by the endless runaround that you finally just give up and go away. Okay, so the next little section says, where there is only one person residing or regularly employed within 300 feet of the alleged public nuisance, written affirmation only that one person shall be required for the director to investigate the alleged nuisance. Okay, so here we find what I call the rich guy's exception. Well, they will allow someone to file a complaint without the other neighbor signing on to the effort. But here's the thing. The only people who qualify that are the ones who don't have any neighbors living within 300 feet of them. 300 feet. That's the length of an American football field. And since it's 300 feet in every direction, that's like living in the only house located in the center of an area the size of 6 football fields. To live in a situation like that, you'd almost certainly have to be rich, which is probably why they offer that special dispensation for those who live in such splendid isolation. In any case, in a city like Santa Rosa, 1 or 2 rich bastards aside, pretty much nobody lives in a situation like that. So this next part says, if, upon investigation, the director determines that a public nuisance exists. Okay, so once again, there isn't going to be any investigation, because before they'll even pretend that there's a possibility they might investigate, you'll first have to form that 3-household vigilance committee in which you're supposed to somehow convince your other victimized neighbors that they should write formal letters of complaint and file them with the court. Then when the trial date eventually rolls around, they're supposed to take a day off from work to appear before a judge to personally testify against one of their closest neighbors. But no matter how hard you try, you'll find that your neighbors are just not going to agree to do that. So there isn't going to be any investigation. Nonetheless, the law goes on to say that if in the course of the investigation that is never going to take place, the director determines that a nuisance exists, so once again I have to stop right there. Because even if there was an investigation, and somehow the head of animal control found himself face to face with your neighbor's barking dog, we're talking about a guy who heads an organization that refuses to accept seeing it for themselves as proof that the thing is happening. What do you think the odds are that that guy's going to be of the opinion that your neighbor's barking dog is a nuisance? Even if you're standing there side by side next to this public official who's watching the animal bark with his own eyes and he's listening to the dog bark with his own ears, the head of animal control will still refuse to officially acknowledge that the dog is barking. That's because the way the law is written, standing there watching the dog bark with his own two eyes, is not enough proof to establish that the dog is barking. He's going to need letters and a firm commitment from your neighbors, which you are powerless to deliver. And in any case, there's something called an acoustic shadow, which is like an auditory dead spot where the sound can't travel because nearby walls or the lay of the land is serving to block the sound waves. So the fact that some of the neighbors might not hear the noise does not necessarily mean that the dog is not out there barking. So that is hardly grounds for refusing to start an investigation. Hell, talk about the deck being stacked. You'll be lucky if you can convince that clown that your neighbor even has a dog, even if he's looking at the dog at the moment you're trying to convince him. But as moronic as it is, that's how they designed this made-to-fail system. And the system is indeed succeeding at failing in a most spectacular fashion. Next, it says the director may issue an order to the owner of the offending animal, directing that such nuisance be abated. So the law says that animal control may conduct an investigation. And it says that they may issue an order. And it says that, but it does not say that they must do either one of those things. So there you have it in a nutshell. Animal control has no mandate to help you with your barking nightmare. And they're just not going to do it. That's because ridding the city of barking noise is not what animal control is about, because they've never received an official directive to do that. The true mission of animal control is to serve the dog industry by seeing to it that dog owners need not suffer the inconvenience of being forced to take responsibility for the untrained, unsocialized dogs that they are bringing into our residential neighborhoods in enormous numbers. In other words, in terms of their actual function, when it comes to barking dogs, animal control is there to thwart your efforts to quiet the animal, so that they might better run interference for your irresponsible neighbor. Now, I realize that if you've never tried to quiet your neighbor's dog by working through animal control, then all this may seem far-fetched to you. But if you've had the experience for yourself, then you know for yourself that that's just exactly what those people are about. Then the last part says, in the event that the owner does not comply with the abatement order, Let me pause here to point out that they are talking about an abatement order that's never going to be issued in the first place. In any case, they go on to say, in the event that the owner does not comply with the abatement order, the director may immediately refer the matter to the district attorney for prosecution of the public nuisance. So there it is again. They're talking about what the head of animal control may do. They're not talking about what he must do. They're talking about what he may or may not do. So if by some miracle you get that far, which is never going to happen in a million years, the director of animal control may or may not refer the matter to the district attorney, who may or may not refer it to the court. But even if all that happens, which is extremely unlikely, it is still not going to help you with your barking dog ordeal. Because as you'll learn in another of our videos, even if you get that far, the court is not going to help you either. Also, notice that the law refers to chronic barking as a nuisance, thereby minimizing the dangerous nature of the barking pandemic. Chronic barking is not a nuisance. It is a severe threat to the public health and a grave threat to your well-being that imperils both you and your family. All right, in a few seconds, a link will appear on your screen. Just click on that, and it will take you to the next video in our sequence series about the barking laws, where we will continue our discussion of the multiple household law, which is probably in effect where you live. Okay, watch for that video. It'll be coming up in just a second.